has the mental capacity that Dr. Oberlander talked about, he or she can make their own calls on that.
And one of the things the Virginia Administrative Code says is that you have the right to refuse treatment at any point. So if you have capacity, you can say, Doc, I don't want that restraint, I don't want this. But you also have the right to be notified of any change in care. So if your loved one has capacity, they should be being told, we're putting you on Haldol because you're a pain after 6 p.m. I mean, technically, they have the right to refuse that medication if they have capacity, or whoever has the right to make that decision healthcare-wise has the right to refuse.
Right. But if the nurse calls the doctor and says, you know, we really need to get Mr. So-and-so with the restraint because we simply don't have the time to, you know, care for him properly, more than likely the physician will say no, that's not a justifiable reason. But of course that patient then is perhaps likely to be prone to falling.
And that's a balance that we always see. I mean, one of the things that defense attorneys love to bring out is that your patient had the right to refuse her meals. And I say, yes, but her desire was to live and have nutritious food. That was also her right. You know, I don't see where she stands up and says, according to the Virginia Administrative Code, I don't have to eat this if I don't want to. But you're right, there's always that balance.
When I was in rehab after my stroke, I noticed that after 9 o'clock, everybody was quiet. And I couldn't understand what was going on until I looked at my hand the next time they gave me a batch of meds. And there was one pill that I couldn't identify. So I asked her, what is this? It's a sleeping pill. That's how they got everybody to, they had like one person on the floor and they could take care of everybody because everybody was knocked out. Have you ever had a stroke? You don't need any sleeping pills. I mean, it's all you can do to stay alive and breathe. You're so tired. And I pitched a fit. And I said, you're not going to charge me, and I'm watching this bill. Don't give me any more of these. And you tell my doctor that that's what I said. But everybody else was knocked out and didn't know why.
We had a case that we just got in and we looked at the records, and unfortunately they're saying they couldn't get the antibiotics in this gentleman that had sepsis, end-stage renal failure, but they got Haldol in him every day for 7 days.
Right.
So the same thing happened.
You said something that in using the power of attorney, the medical power of attorney that we have, that we set up several years ago, says that he has to be declared incompetent by licensed physicians before the power of attorney goes into effect.
You probably talk about a medical directive more than a power of attorney.
Well, it says power of attorney on the front of it.
I'd have to see the document to see which.
That's not standard.
It's not standard. Was that done in Virginia?
Yeah, right, in Roanoke.
Usually you see that kind of language where you're talking about a resident's right to refuse life-prolonging procedures like respiration and that sort of thing, and not in the context that you're talking about. So that's a little bit of an unusual language in a power of attorney.
What can you do if you don't have a power of attorney giving you that special?
Well, that is a problem, and Dr. Oberlander and I have talked about that issue once or twice before. Lots of times what happens, a resident can be admitted to a nursing home and have full mental capacity, and before you know it, that person has gone downhill to the extent that a family member thinks, hey, I've got to get involved here. I've got to be the legal person making decisions. Yeah. Well, have you waited too late? Has that resident lost the capacity to give you a medical power of attorney? It's an issue.
That's not too uncommon. No, that's known as a contingent or spring power of attorney. What she needs perhaps is just the normal power of attorney, which comes into play whenever she wants to use it. The other one, the contingent or springing power of attorney, is one that is conditioned upon the maker of the power of attorney not having capacity.
But you'll run into the other problem, Peter, and Mark can talk about this more than we can, but if it doesn't say medical power of attorney and you get into an issue with regard to making medical decisions, then the healthcare provider may say, well, I don't know if you have the right to make that decision. It doesn't say medical issues.
Right, but the contingent or springing power of attorney has a provision in it, that determines how you go about deciding.
And Mark does this for a living, so we'll defer to him.
Well, I was going to say there's a default statute in Title 54 that when somebody doesn't have, isn't appointed a medical power of attorney, there's a default statute with a priority based on certain stats prior to needing to go before a guardian, to get guardianship. Sometimes you don't have to get guardianship.
The issues that we've talked about, and Lauren and Gary and I talked about this in preparation. I mean, you really could do a day-long program on any of these issues because there's just so much information out there, and we're a little bit hesitant to sort of just touch the top of the iceberg and then run away, but there's a lot to it. I mean, we were talking earlier about the arbitration agreements that Lauren mentioned about. There's a provision in Virginia law that allows you to get out of those arbitration agreements if you act real quick. And arbitration agreements basically on the admission contract will be buried on the 4th page in small print at the bottom that says the facility can sue you if you don't pay their bill, but you can't sue them if they provide bad care. So
Well, they consider contracts of adhesion.
they damn well should be, but
What?
they damn well should be, but they're not in Virginia. They're legal in Virginia.
Okay.
Any other questions? All right, folks. Oh, yes, ma'am.
I just have one quick one, but I don't know, in terms of paying for care in nursing homes. And this has to do with married couples in particular. One of the people is able to live independently, they play the city.
Exactly.
Whereas the partner is placed in a nursing home. Now, in terms of, I know there's a spin down process, on Medicaid, but in terms of, do nursing homes have the authority to take the survivor's house?
Only if you give it to them.
Right.
Hi, Bob. I have a question for you. Looking at all of these things that you talked about, talking about the nursing home, it seems that it's